बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलाम अलैका या रसूलल्लाह वस्सलाम अलैका या हबीबल्लाह। प्यारे व्यूअर्स, मैं हूं मलिक फैज मतवाड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरा यूट्यूब चैनल। उम्मीद करता हूं आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी जिंदगी अता फरमाए। प्यारे व्यूअर्स, आज हम पढ़ेंगे सेक्शन 496। इन व्हाट केसेस बेल टू बी टेकन when any person other than a person accused of non-bailable offence is arrested or detained without warrant by an officer in charge of police station, is arrested or detained without warrant by an officer in charge of police station, or appears or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceedings. Before such court to be given bail, such person shall be released on bail, provided that such officer or court, such persons shall be released on bail, provided that such officer or court, if he or it thinks fit, may instead of taking bail from such a person, discharge him on his executing a bond without sureties for his appearance as hereinafter provided. Provided further that nothing in this section shall be deemed to affect the provisions of section 104 subsection 4 or section 117 subsection 3. सेक्शन 497 सेक्शन 497 when bail may be taken in cases of non-bailable offences. Number 1, when any person accused of non-bailable offence is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court, he may be released on bail, but he shall not be so released if there appears a reasonable grounds for believing that he has been guilty at fault of an offence punishable with death or imprisonment for life or imprisonment for 10 years, provided that the court may direct that any person under the age of 16 years or any Sikh or person accused of such an offence be released on bail, provided that further that a woman accused of such an officer offence shall be released on bail if as if the officer is bailable notwithstanding anything contained in schedule second to this code or any other law for time being in force, provided further that a woman may not be so released if there appear reasonable grounds for believing that she has been guilty of an offence relating to terrorism, financial corruption, and murder, and such offences punishable with death or imprisonment for life or imprisonment for 10 years, unless having regard to the fact and the circumstances of the case, the court directs that she may be released on bail, provided further that where a woman accused of an offence is refused bail under the foregoing proviso, she shall be released on bail if she has been detained for a continuous period of 6 months and whose trial for such offence has not been concluded, unless the court is of the opinion that the delay in the trial of the accused has been occasioned an act or omission of the accused or any other person acting on her behalf, provided further that a person accused of an offence as aforesaid shall not be released on bail unless the prosecution has been given notice to show cause why he should not be so released. Number second, if it appears to be to such officer or court at any stage of the investigation, inquiry, or trial, as the case may be, that there are no reasonable grounds for believing that the accused has committed a non-bailable offense, that there are sufficient grounds for further inquiry into his guilty. The accused shall, pending such inquiry, be released on bail or at the discretion of such officer or court on the execution by him of a bond without sureties for his appearance as hereinafter provided. Number third, an officer or a court releasing any person on bail under such section 1 or subsection 2 shall, regarding writing his or its reasons for so doing. Number fourth, if at any time after the conclusion of the trial of a person accused of a non-bailable offense and before judgment is delivered, the court is of opinion that there are reasonable grounds for believing that the accused is not guilty at fault of any such offense, it shall release the accused if he is in custody on the execution by him of a bond without sureties for his appearance to hear judgment delivered. Number five, a high court or court of session and in the case of person released by itself, any other court may cause any person who has been released under this section to be arrested and may commit him to custody. आज तक के लिए बस इतना ही। कल इंशाल्लाह एक नई वीडियो के साथ आपके पास हाजिर हूँगा। और मेरी आप तमाम दोस्तों से, नए आने वाले दोस्तों से गुजारिश है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। अल्लाह आप तमाम दोस्तों का हामी और नासिर हो। पाकिस्तान जिंदाबाद। अल्लाह हाफिज़।